Good morning, everybody. How is everybody doing this morning? I am doing much better. Hi, my name is Debbie. Welcome to my channel. We don't have central heat in our house. And it was cold in here yesterday. It was 21 degrees when I woke up yesterday morning. I rolled over and I looked at my Alexa and it said 21 degrees. And I rolled back over and I said, I thought I lived in Florida. We had no water because our pipes were frozen. I had really intended to stream at 12, but the house was still not warm. So by then it had warmed up to like the 30s, close to 40s at noon. It was still, that's not usual for Florida. You guys, I do the whole, I'm a Floridian, it's cold when it's 50 degrees thing, but like 21, we don't know how to function in that kind of weather. We just don't. Travis even had pool noodles that he cut, like he split to wrap around the pipes going to the pump and a blanket over it. And our pump still froze. And we had water running outside too. So, it was cold. I was like, I had a rough weekend. I'm just going to stay in the warm bed today. Good morning, Judy. Good morning, Michelle, Wiggles, Jennifer. Look, all my friends are here. Hi, guys. So I went, I forgot to send the picture to Messenger so I could share it. So what I did this weekend, for crying out loud. So the ride dinosaur at Animal King. Stop it. The dinosaur ride at Animal Kingdom closed. Oh, thank you. Yeah, because we had the oven on all night to warm up the house. We didn't do it last night. Yeah, we did that, but our septic tank is acting up again because we need a new drain field and we can't afford one. So hi Terry. So Travis left it because I told him, I'm like, the septic tank problem is going to be cheaper to fix than busted pipes. Like if we have busted pipes from freezing, we're not going to have water. We don't have the money to like redo the pipes. We're not going to have water for however long it takes to raise the money to get the pipes fixed. So he left a trickle of water last night and then he got in the middle of the night to go to the bathroom and he said the toilet was filled all the way up to the rim. So he shut off the water so the water would go down. And then when I got up this morning, there was no water in the toilet. I'm like, what is happening to the water in my house? So we got to call the septic guy back to come out and look at our septic tank again. But yeah, we had the oven on last night, but the night before we didn't leave it on. Like we do it during the day. But when it was that cold, we should have done it at night and we didn't. So we did it last night. And so if I'd opened up with it on and then open up underneath the sink, That might have the heat from the oven, which is right across from the kitchen sink, that probably would have worked. So I will tell Travis if I can remember. But thank you, Nichelle. That's great. Because yeah, we no water. So Saturday I went to Animal Kingdom because the dinosaur ride closed forever on Monday. And I wanted to go say goodbye to it. I tried to live stream it, but it didn't work because it is a very, very rough, bumpy ride. And the gimbal just wouldn't hold the phone. Like the phone was too heavy for the gimbal with all the jerking around. And then I was in the back seat on an outside seat, which is usually the fun seat, but not when you're only holding on with one hand. So halfway through the live stream, I was like, oh, screw the live stream. I got to hold on. So this is what turn? Yeah. Okay. So this is the picture 2026 dinosaur. I tried to look. This was the second time I wrote it. And I'm looking, what you can't see in the picture is a big Carnotaur off to our right. So I'm trying to look scared. I didn't want to overdo it. So I was like, okay, low key scared, like apprehensive. And then this is the one where I'm trying to record it. So my phone is all crooked on the gimbal and everything, and I'm trying to get it all straightened out. And I was like, I gotta write it again. I gotta get a better picture. So the first time I was in line for 110 minutes, and the second time I was in line for 75 minutes. So I did those two things, and I did Flight of Passage, which is the Pandora ride, and you feel like you're riding on the back of a banshee. That was the most amazing thing I've ever seen in my life. You going? No, not yet. Where's my charger? It's in there. You still got charge? Or? Probably not. It didn't have charge when I took it with me Saturday. Nope. It's in the zipper. It's in the zipper pocket right there. So, Flight of Passage, you go into this like chamber, and you stand on the number they give you, and there's a big screen at the end of the room. And they're like, okay, we have to check you for Pandoran parasites. Move around. And then as you move around, you see yourself on the screen moving. And then you see these like greenish blue blotches show up all over you. And he goes, you all have them. We have to decontaminate you. And so then there's like lights flash and air like squirts down on you from the ceiling. And then you go in the next room where you get like your training session or whatever. So then you go in and you sit like a bike, kind of. Like you straddle it, and it's got like a thing going around you, like around your chest. Or not really your chest, maybe like around your belly. But inside where you put your knees, there's two pads so it feels like they're breathing. So it feels like you're actually sitting on them. And then you get 3D glasses, and it's a wide concave screen, and it you feel like you're flying on one. It's absolutely amazing. And your banshee goes down and skims the water, and water droplets of water splash on your face, and it was just the most amazing ride. I think the only bad part was the guy next to me wouldn't shut up. the whole ride. He was like, "Oh my god, this is so amazing. Isn't it crazy what your eyes and your brain do? It feels like you're really on them, but we're not even going anywhere." I was like, "Oh my god." I wanted to just say, "Would you please shut up?" But I didn't have time to write it again, and that was a long line too. Um, so I was going to do some other stuff, but at 4:30 it was so cold I couldn't stand it. I don't know what the temperature was, but I don't leave theme parks early, because I'm like, gotta get my money's worth. That's the way. I need to be there when it opens and stay till when it closes and do as much as I can. Not Saturday. Oh my god. That cold, that wind, when the wind started, it hurt. It was like a knife. That sounds like fun. I went to Las Vegas when I was 4, before they had all the cool stuff they have now. I wanna go back. I don't wanna gamble. I don't like gambling. I don't to me, I don't understand gambling addiction. I don't understand gambling, period. Because to me, you waste a lot of money to make money, and you might not make the money, and you rarely get as much back as Like, I don't understand it. Well, yeah, when they win money, yeah, and then you get a high from the win, but then, like, you get the high from the win, but you're not gonna win. You're gonna lose more than you're gonna win. Like, I don't get it. Yeah. Um, my mom, good lord, I remember when I was a teenager, we went to the fair. Yeah, I've played slots before. To me, that's a little different. I don't know. 'Cause I mean, I guess because it's just quarters. I don't it's probably more than that now, but, um oh, well, nickel slots. Yeah, that's nickel. Duh, Debbie. But, yeah, I've played quarter slots on, a cruise ship. I can't remember if I did it when we went to Atlantic City because I had that migraine and I couldn't even stay in the casino because it was so loud. But, yeah, I wanna go to Las Vegas and do, like, the theme park stuff and the shows and oh, I've never played roulette. But when I was a teenager, we went to the fair, and then I will never forget this as long as I live. Because I was even like, "Okay, mom, let's quit and go ride rides." It was called a splashdown machine, and it had, like, tiers that would move, and you dropped a coin in, and then the tiers would move, and it would rake stuff into a receptacle that you got stuff out of. And it had special coins in there, and if you get 3 of the coins, you got a stuffed animal. So my mom was determined to win me that stuffed animal. So she had me playing and her playing, and we were both trying to get 3 coins. Now this was back in the '80s. I think we spent $13 trying to get a little bitty stuffed animal. But I was like, "I don't want it anymore, mom. Can we go ride one?" Oh my god, and, skee ball. If we ever went, like, to Chuck E. Cheese or something, tickets coming out of the thing, we couldn't get her off the skee ball machine. Yeah, I wanna do that. I wanna go to Vegas because, like, I have pictures and movies and stuff, but it was so different I mean, completely different. It doesn't even look like the same place. So, that sounds like fun, though. Um, yeah, I don't the 3D effects weren't, like, in your face 3D effects, and a friend of mine and I was talking about it, So I was like, they could do without the 3D glasses because, that's just like, I don't know. It aggravates me to have to wear 3D glasses. But she said that there's probably more 3D than we realize to make it look like so immersive. It's like layered that we just don't realize it. Because the only thing that looked like in your face 3D was like some birds flew out like at us. But oh wow. Yeah, I would like to go, but I wouldn't. I mean, I might do slots, I don't know, but like I wouldn't gamble. I would just like sightsee stuff. Oh. So that was my weekend. And then so I was frozen yesterday. I was like, I really should get up and go stream, and then it was like 11 and I'm still in the bed like, "Oh my god, why isn't it getting warm in this house?" So yes, I'm a wimp when it's cold. I live in Florida. So don't hate me because I didn't stream yesterday. I was cold. Okay, so whenever we stopped Kyle Rittenhouse on Friday, we were almost to the end of day 8. But I don't know why I didn't just finish out day 8. I guess we were already behind. So and it's just like I think they rest. I think it's time for closing arguments. Um yeah, but oh, is it not so hot? Oh yeah, I guess it wouldn't be in March and October. My father-in-law plays no, not volleyball, softball. And he does a tournament there every year. My mother-in-law hates it cuz it's so hot. She can't stand it. Okay, so we're going to finish up day 8, which I think is just them resting and the judge giving some instructions or something. Is really really short. And then we'll go to day 9, which I think is closing arguments. I haven't put a new poll up for the next one. I got to do that today. Oh, and I almost forgot. I made a new member level, and I'm going to do a monthly giveaway for anybody that's on that level. It's $1.99 because my regular membership is 99 cents. So I made a higher one at $1.99. So whoever joins that will be entered into a monthly giveaway. And I also still want to do a giveaway when I hit to my members, when I hit to all of the members, when I hit 1,000 subscribers. So none of my incentives have ever worked so far, but oh, cool. Thank you. I cannot believe I've had members for 7 months already. Crazy. Crazy, crazy. Okay, so we're going to finish day 8, and I think it starts closing arguments or jury instructions or something. And the Banfield, wow, 9 months. Man, I think when is my 1-year anniversary of having members? I think it's either this month or next month, I think. But no, then maybe it is 3 months from now. I don't know. Anyway, so the Banfield verdict is in, but we're going to go ahead and finish the trial. I know the verdict, but please no spoilers. Yeah, we haven't even seen him testify yet. So we're going to try to finish that up this week. Juliana's, I can't say her last name, the au pair, Her sentencing is on February 13th, and I want to watch it if we can. I hope there's not another trial or whatever going. I mean, I guess I can make a video if we don't get to do it live, but I want to see her get 10 years at least. So I want to watch her sentencing. And then Banfield's sentencing is May 8th. I don't know why they put it out so far. I don't understand. They're doing like I just told you the verdict, didn't I? I need to do that. Crap. Oops. Okay, forget I said anything. You know nothing. Yeah. Margulies? Is that it? Margulies? I don't know. Between the attorneys calling her different things and the closed captioning calling her different things, I don't know her name. Yeah, I have a doctor's appointment. Oh, wait a minute. That's the day of my doctor's appointment. I was going to say I have a doctor's appointment on a Friday the 13th. That is that. Ugh. Well, dang. That is that day. I was thinking there was 2 Friday the 13th this year, and it was a different month, but it's not. Everybody butchered it. Yeah, I have no idea how to say her last name. Okay, let's get to Kyle.
No further rebuttal witnesses. Any other evidence? Judge, I would move that the exhibits be accepted and published as previously requested. Any objection? The same objection that
I was like,
it'll be received and
what does that mean?
published. Did you have some for publication too, or was that done? That was completed? Yes. Okay. All right then. Folks, the evidence is closed, and I'm going to ask that you return to my. Yes, you do. Go ahead.
Can we get the screens on?
Did you? Hey.
So this is after. Yeah, I see it now. And I was trying to make sense of you saying it, though. I couldn't, but now I see it.
This is exhibit 155.
What is that? I can't even tell what that is.
And now please exhibit 156.
So the last witness has left the stand. I don't know what they're showing the judge. I don't know why they're even showing the judge this stuff. Oh, yeah, that's crystal clear.
Claim it. All right, that's all. Thank you, Judge.
All right. All right, folks, the evidence is closed. And you know what? I want to talk to you lawyers for a moment. I guess I'll ask you to step into the library for just a second. And please don't talk about the case.
Yeah, where is Marty? What?
All right, now you have driven me
Well,
into
get up here and
submission
watch your trial.
with your request to
here.
argue on Monday, but I'm going to extract something in exchange, which is a cap
Here.
on
All
the
right, well,
length
get
of
up
your
there yourself
arguments.
then.
I figure,
I'll
well,
use
first
the
of all,
keyboard for you.
just we're going to do a more involved discussion on instructions and verdicts. Are there going to be any charges submitted to the jury other than what is in the information? Yes.
The state will ask for that, yes.
How many additional charges are you going to submit? Or request to submit?
I'm not sure if we finalized our request.
Hey,
Certainly
Teresa.
on count 3 and 4. I think we've discussed on other counts, but the first degree homicide, first degree intentional homicide, we will ask for all lesser included. The attempted homicide to engage gross rights, we would ask for I believe there's only one lesser included. We are not inclined to ask for lesser included on the reckless endangering safety charges. At this moment, we're not inclined to ask for lesser included on count 1 to Mr. Rosenbaum, but I think we need to discuss that more fully.
Oh my God.
Are there going to be any special
You've
instructions
got to
other
be
than what
kidding
you've
me.
already submitted? And the sixth count affirmative defense instruction from either side?
I believe the state will be asking,
Me a hug.
we gotta discuss this more, but I think we'll be asking for the provocation instruction. 805, I believe.
Okay, yeah, okay.
What is up with you?
Well, the reason I'm asking right now, I'm not going to hold you to this, is that I figure that the instruction probably will take 45 minutes, I would think.
To read that to the
Shadow.
jury?
Yeah,
Yes, I would say.
You're making the screen black.
and so that leaves how much of the day, since you scared me off from tomorrow because you said, well, the jury will be worn out by the time we get there. So I think, well, I don't want to wear them out on Monday either. So if
She's
I'm
hitting the
instruct
screen with her
for 45
tail.
minutes or an hour, that takes us to 10, 10:30, 10:15 anyway, 10:30. So maybe if you were going to confine your arguments to maybe an hour and a half apiece, is that reasonable?
Very. I request
Total time,
including rebuttal.
total time.
The state is going to need 2 hours for our primary, and I'd say half an hour for rebuttal, Your Honor.
You know, I had the good fortune to be across the street neighbor to living across the street to the late Kenneth Grube, United States District Judge, when I was a lad. And Judge Grube is famous for his statement that the brain cannot absorb what the seat cannot endure. And if you don't like that advice, President Roosevelt, one of the renowned speakers of the 30s and 40s, when asked by his son for some advice on speaking, said, be sincere, be brief, and be seated. And so the message is loud and clear. Are you saying 2.5 hours to argue your case?
I'm saying that I think that the initial closing may take up to 2 hours. I'm not going to aim for 2 hours, Your Honor. Obviously, I understand that, but I want to have the freedom. There are a lot of videos, and we're going to be showing them. So there's going to need to be time for that. It's not just going to be standing up groaning for 2 hours, but there's going to be time when we're going to need several minutes. I don't even know, probably 30 minutes worth of video that they may be watching at various times, which no one's going to be talking. It'll just be playing that. And I certainly don't want to be in a situation where our allotted time for closings, you propose an hour and a half, for example, we do an hour and 10 minutes or whatever to save 20 for rebuttal. I can't possibly budget rebuttal time because I don't know what the rebuttal is going to be. So I'd like that. We can put a cap of 30 minutes or something on it, but I don't want that to come out of the first closing period of time, and I don't want to be limited. I don't want to have to budget that right now out of that first closing time. So if the court is disinclined to go along with that, then I would propose an hour and a half for our primary closing, an hour and a half for the defense, and then a maximum of 30 minutes for rebuttal.
They should get no more time than us.
Well, they won't.
Okay.
They won't.
Whatever the time
No.
the court says,
Yeah.
I'll deal with it. I think an hour and a half is adequate.
I agree with you that, and you make a good point about the number of exhibits, and so I'm going to indulge total time of 2.5 hours each side. But with that, I'm usually pretty permissive when people go a little bit longer than they should. I note it to the jury so that the jurors can make their own. If they get annoyed, they get annoyed. But I just warn the people. But I'm going to be a little bit tougher, and I may tell you to just sit down in mid-sentence if it keeps going. No, seriously. And I did it. I did it to one of your one of the DAs that in the last several sequences and in mid-sentence. So 2.5 hours per side, and yours is to allocate as you wish. So we need to come back tomorrow. Tonight, you may send me your proposals for lesser included and any special instructions or the numbers of those you want. Well, let's get the jurors in, then we'll take care of these details. Yeah, with the same appearances, except the jury's not here, and we're here to talk about instructions and verdicts.
I
And,
kind of
the
thought
district
that
attorney
Harris
has
played him like
requested
too
a
weak and feeble, but that was kind of
multitude of lesser included offenses.
how he was portrayed in the books because he was powerful and strong,
Here, all of them opposed.
and by being seeming like a feeble old man, it gave him even more strength because everybody underestimated him.
I'm looking at their.
So
Sorry.
back when I first watched the movies, I liked Michael Gambon better because he was stronger and more forceful. But now looking back, I think it would have been better
I have
with
count one,
Rutger
just
Harris
the
through the
first
whole
degree.
entire
I'm sorry,
series.
the
And I don't
First-degree
know
reckless homicide, I
anybody
didn't see
that can play
any
Snape
lesser
any
included
better
on that.
than
Are we actually-
They asked for
Alan
1020.
Rickman.
Did you get their written request for instructions?
So I'm not expecting this
They
series
asked for
to do
1022.
well.
Oh, yeah, there was an email last night. Did you get that?
I did.
Okay, they asked for 1022, which is not the standard for first-degree reckless homicide. It's
The new Harry
It's the
Potter
standard
series
for
that HBO is doing,
first-degree with a
the
lesser
cast
included of second.
is
Okay.
just so not.
We're not asking for that, but I understand the court might get it.
Okay. Are you objecting to it? Skip?
Yeah.
Yes.
Want to discuss it briefly, or just impose or argue, object for the record?
Yeah. And
I guess I would just object.
since somebody threw me a squirrel. Now you guys know I'm not a racist. I hate that I even have to say that. Anyway, the person that they got to play Snape is a black actor, which I don't have a problem with, except for one thing. Harry Potter was suspicious of Snape and disliked him and didn't trust him through the whole entire series until the very end. And he had a reason to, but he didn't know because he couldn't. Yes, exactly. But he didn't know. Hey, Colin! So he didn't know why he didn't trust and didn't like Snape. So now they're going to put a black actor in there that he's going to distrust and dislike. And someone is going to absolutely start making it about race. So I don't know why. I hope it doesn't happen. I sincerely hope it doesn't happen. But I don't know why they cast a black actor in that role. Which, like I said, I don't have a problem with a black actor in any of the roles in Harry Potter. Go for it. But that one is the one that's not trusted and is suspicious, and that's going to end up being, you know what I'm saying? Like, people are going to start calling it out. It is Snape, yeah. But let's say it's somebody that was like, well, you know what? I never read the books and I never saw the movie, but they're making a new TV show. So I'm watch it. Everybody loves this thing, you know? So maybe it's somebody that's brand new and doesn't know anything about it. See, like, we get it. If when we watch that and we see him being distrustful of Snape, we're going to 100% understand. But what if it's somebody that's like, oh, wow, I want to watch this because everybody loves Harry Potter and I don't know anything about him or whatever. Did they finally make a movie? Because I never did see the movies. I never even finished reading the books. I need to go back and start over and read the whole series. But because I remember back when there was only like 2 or 3 books, they were like, oh, this could never be made into a movie, but now we can do anything. Did it get bad ratings? That stinks because everybody was so looking forward to them. Like when CGI and everything came into its own, everybody was like, now we can have a Dark Tower movie, and everybody got all exciting. So that's terrible that it got bad ratings, but the books are hard to get through unless you're like an avid fantasy reader. It's not horror, it's fantasy. But yeah, I think I read the first 2 and part of 3. And then when he got hit by that van, everybody was like, oh my God, he's going to die before he finishes the Dark Tower. I was like, people, good Lord. You should just worry about him, whether, like, pray for the man to get well. Don't just say, "Oh, I want him to live so he can finish his magnus opus." I mean, good Lord. Oh, Idris Elba played him. Cool. I like him. Okay, back to trial.
Okay. All right, then, I'm not going to decide right now because I just got your filing this morning, which was sent to the clerk in Kenosha. They sent them to me directly. And I know you're not familiar with that procedure, so. And actually, I wish less people had my email right now. But I think that's probably a common feeling. But I will, what I plan to do is to send, at some point tomorrow, I will send you what I expect to deliver as the final instructions and verdicts. And I would just, now, given the evidence, well, I'll leave it at that. And then we probably will have what I hope will be a brief discussion on Monday about it. And at least you'll have,
Okay, Judge Schrader, what are we doing? Oh no!
I guess I will talk
I'm
about
letting
it for a
people
minute.
leave talking
The
about
difference
Harry
between
Potter.
first and second
Come
degree.
back. We're
and
doing the
asking
trial
why it's
now.
admits second degree. And
You're welcome,
it's in
Colin.
the instruction itself, on the bottom of, well, I don't want to say bottom because I don't have them displayed as they would on the page, but on instruction, the instruction you've requested, which is 1022.
Hey, Nancy.
Under the heading, difference between first and second degree reckless homicide. It says the difference between first and second degree reckless homicide is that the first degree offense requires proof of one additional element, that the circumstances of the defendant's conduct showed utter disregard for human life. Then, of course, the standard for submitting the lesser is that there's ground in the evidence to acquit on the greater and still convict on the lesser. Where's the absence of evidence of utter disregard for human life?
Judge, there was a line of questioning on the cross-examination of the defendant in which Attorney Binger asked, I believe in regards to each person shot or shot at, except for that of Mr. McGinnis, I suppose. If the defendant, I can't remember the exact wording, but if he even cared if he killed the person alluded to. So I believe that the defendant denied that he said he had to shoot him. He denied that he did not care about their life. So I believe the jury could find, based on that line of questioning, as well as just the evidence in general, that the defendant did not have an utter disregard for human life, as he testified. He testified that he essentially had regard for human life because he felt he had to do it, and he didn't really want to kill anyone.
Well, the circumstance. Well, let's hear from the defense.
Element 3 is the circumstances of the conduct showed the utter disregard for human life. And in terms of the evidence in the case, I think the testimony was he didn't want to have to do it, but he did it to defend himself. So as I said in our instructions, I don't think that there has been any evidence offered which would support the lesser included on count one. So I would ask the court give 1020, which is the first degree reckless homicide charge, along with the self-defense instruction, and that'd be that, because I think that's what the evidence shows.
I'm going to do a colloquy with your client when we get done with all this. And don't let me forget, please.
I've discussed it with him.
Yeah, but I had to talk to him
Right.
personally. The instructions says, in determining whether the circumstances of the conduct, and that's a correct point, the conduct showed utter disregard for human life. Consider these factors: what the defendant was doing. He was firing a gun into, let's see, this is count one, so we're talking about Mr. Rosenbaum. He's firing a firearm 4 times into a human being with fatal consequences. Why he was engaged in that conduct, how dangerous the conduct was, well, that's self-evident. How obvious was the danger, that's self-evident. Whether the conduct showed any regard for life, and all facts and circumstances. I don't see it, and I don't see it. Help me out where I'm going wrong.
Hey, Warrior.
Judge, he was asked if he, not only did he, how he felt about killing them, but if he knew that his conduct would have killed him and that firing that gun would have killed someone.
This element is on first degree, which is what we're not talking about, is whether he knew or was practically certain. And we're talking about reckless endanger or reckless homicide. So, I mean, to fire a gun 4 times into somebody, you don't think you'd know or have or be practically certain that that could have fatal consequences?
I would, but the defendant denied that it would.
He didn't. I didn't hear him deny it. He said he was protecting his own life. I thought he was, when he was being asked repeatedly, and correct me if I'm wrong, he was asked repeatedly questions along the line that you indicate, and he responded, "I was trying to defend my life."
He was also asked the line of questioning, you knew if you shot 4 shots that you would kill him, and he denied that he would have that knowledge. So I mean, I agree that, I mean, I obviously think that it's under disregard because that's what we charged it as. And that's what we have presented to the jury. But I believe a reasonable jury and a reasonable juror could, based on the defendant's own testimony, not find utter disregard for human life. And that's the standard, not what we think, but what a juror could do.
I wish I knew the exact answers that were given. I'm not sure. And I when I say that, it doesn't mean I'm embracing your interpretation of what that would mean, but I would want to be sure exactly what was said anyway. So, are you able to identify when in the examination? Because you had a very lengthy examination.
Check my notes.
And, unless it's crystal clear, my suspicion would be if it turned out that the defendant would be acquitted, well, not acquitted, but if the jury returned a verdict on second-degree reckless endangerment with this description of what constitutes the crime, if they returned a guilty verdict over the defendant's objection, I would expect to be reversed.
On second-degree reckless endangerment?
Yes, homicide, I'm sorry.
So you're saying if the jury finds the lesser
On this charge,
and the defendant objected
over the defendant's objection,
and you accepted it,
right?
you felt it'd be reversed?
Yes. Unless you can come up with this crystal clear language that the defendant, and again, we're back to the circumstances of the defendant's conduct showed utter disregard for human life. So I think his thoughts on the subject would be relevant, would be a legitimate factor. But when I consider the others, what he was doing, firing into somebody 4 times, why he was engaged in it, there was dispute about that. But either it was it would certainly be reckless under any circumstances, and except under privileged circumstances. How dangerous it was, how obvious was the danger, and whether the conduct showed any regard for human life. And if anything, it seems to me he would have indicated, if you interpreted his answer, it would be an indifference. Although he did say at one point that he didn't want to kill anybody, but it would be an indifference, because when he's asked about his intent, what was the question you're saying again?
There was a line of questioning on if you.
I don't think he meant to kill them. I think he just shot because he was in fear for his life. So, I mean, you can shoot someone and not kill them. Like, Gross Kreutz, or whatever his name is, Gage, he didn't die. So, I don't think he intended to kill anybody. Wrong place, wrong time. Should he have been there? Absolutely not. Should he have had a gun? Absolutely not. But I don't think he intended to kill anyone. I think he was just trying to protect himself. That's purely my opinion. You can have another one. That's fine.
If he cared about killing someone or cared in that regard, and there's a line of questioning is you knew that firing the gun could cause death, and I believe he denied or indicated he didn't know.
I don't remember that. Did
Everything that he said, I mean, the reality is everything was an intentional act. Now, they haven't charged it that way, and I appreciate that. But looking at the definition of utter disregard under the statute, I'm not going to repeat. I'm going to hold the same ground that you've already done. Firing 4 shots, we have evidence that the man grabbed the barrel of the gun. So we're talking about a distance of inches, not always feet, but in some situations, inches. It is the only logical conclusion would be that a person would believe that conduct, if they were convicted, would show an utter disregard for human life. If self-defense isn't accepted, there's no other reasonable conclusion that can be drawn from firing a gun somewhere between 1 and 4 feet, all the way down to inches by the soot on his hand. So I think that's what the evidence showed. And I think that's really the only evidence regarding the utter disregard portion of the statute. So
if the defense is willing to stipulate to the third element, then that's fine. We can go with that way. But it seems they're not arguing it. And if we want to go that way, then we can.
Conversations with lawyers are always interesting.
And if they're not willing to stipulate, then obviously there must be some disagreement, or they must be trying to argue it. So I believe that there is a basis. I cannot recall at this moment precisely where in the cross-examination it occurred. Obviously, it was lengthy, and I was the one conducting it.
The examination, as I recommend, as I recollect it, was that the defendant was repeatedly asked about the question about his thoughts on the subject of the death or survival of the target, and invariably responded that he was trying to defend himself and that he'd be killed if he didn't. And if anything, I would interpret it as an indifference towards the outcome with respect to the target, which is not identical to utter disregard.
Right. Right. So if he's indicating he has an indifference, that would be second-degree reckless homicide.
Now, it would be one factor, and I don't, even if I granted what, I just don't think it's appropriate. And I'll repeat my statement. If I were to give this instruction over the objection of the defense and the jury found a verdict on it, I would expect to be reversed.
Well, are we in agreement that element 3 is present?
Well, don't ask me. I'm not in a position to agree to anything. I'm not going to give that instruction. Or submit that verdict. 1345 and 1347. Second-degree reckless endangerment.
So it's essentially the same issue.
Yeah, it is. So any additional argument on that?
It would be the same for count 3 as well.
I don't remember what part B.
Well, counsel raised a good point to me that he claims he didn't even know Mr. McGinnis was there. So he's firing a weapon he admits does not know the capabilities of. He admits he doesn't know how the bullets can react, that he did not know a flint metal jacket could pass through his target. And he's really showing utter disregard for anyone in the line of fire as he fires 4 shots, including Mr. McGinnis. There's also bystanders. There's a house directly behind Mr. McGinnis. So I believe in firing 4 shots in a somewhat, I would say, wild manner. He is showing that there could be an argument that he says it in, I believe, again, that it's utter disregard, but a jury could find, because he did not know Mr. McGinnis was there, that he was not showing utter disregard for Mr. McGinnis's life, and that the second degree endangerment would be more appropriate.
Defense?
Just give me 1 second here, Judge. Because it stems from, and tell me if I'm wrong on this, because it stems from the actions involving Mr. Rosenbaum, which this court believes the proper instruction deals with the utter disregard for human life of Mr. Rosenbaum. Those actions, to me, are intertwined with the charge involving Mr. McGinnis.
No, I don't think so, because I think the instruction anticipates that he could have utter disregard for.
Reckless endangerment, yes.
He could have
Because he
utter
could have
disregard
shot an innocent
for the
bystander.
life of Mr. Rosenbaum, but still be sufficiently aware to realize the risk to Mr. McGinnis. And then he, under the law, as I read it, he would have the obligation to exercise.
They shouldn't have charged him with murder.
His conduct is in such a way as to minimize the risk
They
to Mr.
overcharged him.
McGinnis, whether privileged or not.
That's why they didn't get a conviction.
He would, even let's talk about his conduct being purposeful, even though it's not charged. If he intended to kill Mr. Rosenbaum, and whether he was justified in that or not, he's still required to execute his intentions in a way with the minimal, or to minimize the risk to Mr. McGinnis. So if, and that's a jury determination, I'm not suggesting I would want to be in that position, who would, but he would have to decide, well, I've got to kill this guy, but I've got to do it such a way that I don't hit anybody else. That's really what the jury's being asked to determine. And there are instances that you could imagine where the person actually would have freedom of choice and a conviction could be appropriate. One might not expect that to happen under most self-defense circumstances, but although for an intentional, then he'd be guilty because he intended to kill someone else.
And here's my only argument is, I think the testimony was the bullet that has endangered McGinnis passed through Rosenbaum, right? That Rosenbaum was shot. There's 5 wounds with 4 shots. So he didn't miss. So the reason that I'm kind of hung up on the utter disregard for Rosenbaum is if he would have missed, I suppose, and you could say that shot was a wild shot.
But he was using steel jacketed ammunition.
Bullets are bullets, Judge.
No. I'm picking at hairs because that's what we lawyers get paid to do. But and of course, if we were in the jury room and we'd laugh at each other for the things that are being said. But in the eyes of the jury, they could theoretically, like how many angels fit on the head of a pin, they could theoretically think, well, it does make a difference because he wasn't using expanding ammunition. He was using a full metal jacket, and he should have foreseen that it might have gone through and that it would endanger someone else.
The defendant also denied knowing he was there, so the jury could very
He
easily.
He did indeed. That was my next point.
My only argument, Judge, was that if he's using utter disregard, or the jury believes there's utter disregard as it relates to Mr. Rosenbaum, the charge as it relates to Mr. McGinnis directly relates to the bullet that went through Mr. Rosenbaum's hand or head or whatever it is, right? So that's why I'm saying if it's that for Rosenbaum, it has to be the same for McGinnis, only because there's not a wild shot. He didn't miss. He wasn't spraying. Nobody's alleged anything like that.
You could say that in your argument, couldn't you?
We
If
could.
I left this on their verdict and you had to argue it, you could say.
I certainly could.
Pardon me?
I said I could.
The evidence does show that he essentially missed the 3rd or 4th shot. There's a graze wound that then traveled who knows where, possibly towards Mr. McGinnis. So this is not as though all 4 bullets entered Mr. Rosenbaum. One skipped right by him and basically had a contact. And the defendant says he didn't think he was there. So a reasonable jury could find that how do you show utter disregard for Mr. McGinnis when the defendant claims he didn't even know he was there?
I'm going to think about this one. My inclination at this moment, to repeat my former statements that have caused some consternation, my bias would be in favor of submitting that verdict and giving this instruction. But if it shows up on your doorstep, your email doorstep tomorrow at some point, and it isn't in there, don't be terribly surprised. All right. Count 4.
So count 3, it's essentially the same issue, except obviously this time the defendant knew he was there. I'll essentially my arguments that I believe firing 2 shots, missing, a reasonable jury could find that he was not showing utter disregard. He only fired twice instead of 4 times. He did not fire into the individual after already striking him twice, as he did with Mr. Rosenbaum. He did not continue to fire. So I believe the mere fact that he fired twice and did not hit a reasonable jury, and again, we believe that first degree is the most appropriate charge, but a reasonable jury could find that because he stopped firing, he was not showing utter disregard.
We are talking now about a jumpsuit? Jump kick.
For blue hoodie man,
What do you call him?
blue hoodie man.
What do you mean?
Oh, Tepster.
Did you want to respond?
It's the first time I've ever heard that missing someone when you're firing from point blank range means that you're not showing an utter disregard for human life. So he fires Judge, he's on top of him when he kicks him in the face, and you saw the shots. It is difficult to ascertain an argument that a jury would believe because he stopped shooting or missed from point blank range with an AR-15 that he wasn't showing utter disregard for human life. I don't think that's a logical argument. I think the appropriate instruction is 1345. They're either going to accept that it was self-defense in that or they're not. But to say point blank range, 2 shots on a man jumping on you, yeah, that might not show an utter disregard for human life because either he missed or he stopped. I don't buy that as logical, and I would ask that you just give 1345.
If his conduct, the standard for the lesser included, I think is still, there is ground in the evidence for acquittal on the greater and conviction on the lesser. The same set of facts. What's the difference between what you're charging and the lesser?
I've stated what I think the difference is. My worry is that the defense, I've asked now a couple times if they're just going to agree that there's utter disregard, and they've not agreed to do that, is that they're going to get these instructions and then argue it in their closings, and then we are stuck. So I would like some sort of limitation.
Why wouldn't they argue in the closings what the instructions are?
That they will argue that there's not utter disregard. That they will argue the opposite of what they're saying now.
No, I'm not hearing that.
Well, then why not agree to it? If they are agreeing that there's
They'd be nuts. That's why. How would that be?
What's that?
They'd be nuts. Why in the world would they concede an element like that?
Well, they're conceding it right now.
No, they're not. They're discussing it for purposes of whether or not the lesser included should be given. They're saying they're not conceding all your evidence. They're saying it's hard to believe that this would constitute or not constitute utter disregard for human life. Let me repeat the question I just asked you. I don't think there's a dispute in the evidence as to this individual, Mr. Jump Kick Man. The video is claimed to depict that he kicked the accused in the head. That the accused turned and fired at him twice and missed. On what ground could they convict him of the lesser without having convicted him of the greater?
Well, I'll stand by the prior arguments of the defendant's own statements. And also, I think it does make a difference that he shot 4 times at Mr. Rosenbaum after he was already crumpling to the ground. The fatal shot was as he was falling to the ground, and he stopped shooting at the man in the blue hoodie. And again, I think the first degree is the appropriate charge, but I think a reasonable jury can say, why did he stop firing? Why didn't he, fire at him as he went away? I feared he might come back and run at him. So I believe a reasonable jury could find that. And frankly, if the defense in their closing argument tries to quibble with the utter disregard, I don't know if there's precedent for it, but I think we're going to ask for lesser includeds after that, because we're going to ask for lesser includeds after that. If they're admitting here that there's no way a reasonable jury could find otherwise, if they're agreeing to that, that's one thing. But
if they're agreeing to that, then why are you asking for a lesser included?
Well, they're not agreeing to it.
But I understand. I actually do understand what you're saying, I think. But let's do it again. Let's talk about the incident involving Jump Kick Man. What he was doing, what the defendant was doing, firing a gun at a human being.
Yes.
He hasn't alleged that he wasn't firing at him. He wasn't saying I was just trying to scare him off with a couple of shots across his bow. He didn't say that. Why he was engaged in it, and he's given his reasons, and I don't think the state disputes them. He was doing it to prevent the man from attacking him, and the state says the man had the right to attack him, and the defense said he didn't. Either way, he was doing it for what he was doing. It was purposeful. How dangerous was the conduct? Well, the defense is not disputing it wasn't dangerous behavior. I don't think they're going to argue that. How obvious was the danger?
The defendant denied that it was obviously dangerous. He said he did not know if it was going to kill him. He did not know that he denied knowing or that his bullets were more dangerous than other types of bullets. He denied knowing that his gun was more powerful than other guns. So again, I think the evidence most.
I don't think that is exactly what
That's because he's a
is stated. For example, the discussion about what kind of guns are more powerful. That wasn't actually it. I was kind of intrigued about it because it was a close contact, and the suggestion was being made by the questioner, Mr. Binger, that the rifle is because it's a more powerful weapon was more dangerous or something to that effect. And of course, in a close contact situation like that, it may be that the pistol is a much more desirable weapon. But I thought that discussion was focused on that type of issue rather than your claim that the defendant was suggesting his weapon wasn't dangerous. That it wasn't obvious, the danger wasn't obvious?
Judge, in his testimony, the defendant said essentially, I was in fear for my life, but I didn't mean to kill him.
Is that what he said, or did he, when he was asked, did he mean to kill him? He said, I was just trying to defend my life, or words to that effect.
He said, I did not want to kill them.
Did he? I don't remember. Mr. Binger
He said,
says
"I didn't
yes.
want to
Mr.
kill-"
Kraus
He
says
said-
yes.
He said,
I think that's fair. At some point or another, he did say he didn't want to kill anybody. That's true.
Anybody that night.
But that's not the element. If if we're first degree, then that'd be another matter. This is reckless endangerment.
We're talking about the defendant's mind and if he had utter disregard.
No, we're talking about how obvious was the danger.
We agree. The state, under their evidence, is showing utter disregard. What we're fighting about is that it's not.
I'm still struggling with what is the basis upon which the jury could acquit of the greater and convict of the lesser, because that's the standard.
If they believe the defendant, they have a basis for the lesser included. There is a basis.
The
They,
defendant
if
said
they accept the defendant's
I didn't want to
testimony,
kill anyone.
that I didn't want to kill anyone, that he bought the gun because it was
That
cool.
would be that. I might even buy into that. I might. Except that would be if we were talking about a charge of count
Or
4, because intending to kill is not an element of this crime.
but it shows whether or not he had utter disregard. If he's firing and not
You know,
considering.
you're getting to the ultimate fact. And I'm telling you what the factors are and determining whether there's utter disregard, and you're telling me that one of the factors to be considered on whether it's utter disregard is utter disregard. That doesn't make any sense.
Well, like I said, I believe the defendant's testimony gives a reasonable jury a basis to find a second degree.
I don't. So I will not give that instruction. Or submit that verdict. And the reason is because I do not feel there is basis in the evidence for acquittal on the greater and conviction on the lesser. Count 4, number 10. You're asking for 1017, which is you're asking for 3 lessers. First, you're asking for first degree intentional. You're asking for second degree intentional, or first degree reckless, or second degree reckless.
Yes.
So now give me the bases for acquittal on each of the greater crimes and conviction of the lesser.
Well, with first degree intentional homicide, obviously there's a self-defense. The jury could find imperfect self-defense and
Okay.
find second degree intentional homicide, that if he did not reasonably believe the force, if it was not reasonable for the amount of force used. The defendant, again, while testifying, said he did not mean to kill Mr. Huber. So they could find from that alone that there is not an intent at all and go to the first degree reckless. And then we're left with the argument that we've been having all morning thus far, which is whether a second degree reckless showing utter disregard would be appropriate. The defendant said he didn't mean to kill him. The defendant gave his reasons why he thought he had to shoot him. But again, I believe he indicated he denied that he knew it would kill him. And essentially it's the same argument that's been being made all morning. But I think it's quite clear that in a self-defense case, second degree intentional is appropriate because the jury could very easily find in this case that it was not perfect self-defense. As a person who is running at him, being told or perhaps even witnessing himself that the defendant has already shot someone, gravely injured them, has already shot at another person missing, and then gone in to try and disarm him. The jury could find that it was not perfect self-defense.
Are you disputing that?
No, first and second.
First and second,
No.
intentional or okay?
So then the reckless, the defendant testified directly that he did not intend to kill him.
Any dispute as first degree reckless?
No.
Okay. All right, any objection to second degree reckless?
For the exact same reasons that we had talked about, Mr. Huber, I'm sorry, Judge, if you already,
No, that's all right.
Mr. Huber has the evidence was a rifle pointed up against his chest.
I didn't hear you.
He has a rifle, according to the evidence, he has a rifle pointed literally up against his chest. So the idea under those circumstances that having an AR-15 pointed buttressing up against your chest would not be utter disregard for human life if believed, to me, that's where it begins and ends. There is no other explanation. So I think first degree, second degree lesser included, first degree reckless are all appropriate. Second degree reckless doesn't fit.
Did you want to respond?
I'll just stand on our arguments before. This afternoon, we may review the defendant's testimony, and if I find a specific thing that I think changes it, will obviously contact the parties.
Okay. I embrace the argument of Mr. Sharafsi. And count 5, you are, and that is the shooting of Mr. Grosskreutz, and that is charged as intent to kill.
Correct.
Okay.
So the instruction I requested is attempted first and then attempted second. for very much the same reasons as Mr. Huber, that a reasonable jury could find imperfect self-defense, as Mr. Grosskreutz was actually facing away from the defendant when he fired. And then the next lesser included, if they don't find intent, is the first degree reckless endangerment. So I've requested that. And then obviously I've requested second degree reckless endangerment, which we've rehashed a few times now.
Defense?
Judge, I don't have an objection to the lesser included on the second degree attempt. It's the same argument. The court heard the evidence and the distance. Mr. Grosskreutz testified that he was about 3 feet away, whatever it was, from him when he was shot. The gun, Mr. Grosskreutz pointed the gun at the defendant. Mr. Rittenhouse then fired. So I think that first degree, attempted first degree, well, you can't attempt a reckless act, right?
I would have told you, I would have agreed with you some years ago, but I'm not sure. I don't know the answer, and I certainly am going to have to hit the books on that. That was certainly once the law.
I would have, you either are, to me, you're either reckless or you're not reckless. So I would object to any recklessness because I don't think you can attempt a reckless act. So I'll leave it at that and let the court ponder that.
Well, the defendant did testify that he didn't want to kill anyone.
I understand that, but I think somebody would say the behavior is either reckless or it's not. I don't know how you can attempt to be reckless or attempt to be negligent. I don't know how you can do those things.
Judge, if I want to respond, I mean, we just basically agreed on the counter by Mr. Huber that reckless homicide was appropriate. Mr. Grosskreutz did not die, so the appropriate charge at this point would be the first degree recklessly endangering safety. The jury could easily find that the defendant intentionally shot Mr. Grosskreutz, which is not, I guess, in dispute, but that he did not mean to kill him. The defendant said multiple times, "I did not want to kill anyone." The jury could also find that shooting someone in the arm, if they find that was where the defendant was aiming, would not be intent to kill, but it would be recklessly endangering his safety. If the jury does not obviously find that it was perfect self-defense.
Is it a lesser included?
Yes.
Statutorily?
Yes.
Yeah, I think you're right. Because otherwise, why couldn't they convict him of both? But why get into a discussion we don't need to resolve? We'll do it later.
Just in case anybody doesn't know, perfect self-defense is when someone is actually threatening your life. Imperfect self-defense is when you think someone is threatening your life. They may not be, but if you have a reasonable fear that someone is threatening your life, whether they are or not, and you act in self-defense, that is imperfect self-defense. But imperfect self-defense is iffy. You know, it doesn't always, that's why it's imperfect. But perfect self-defense means, yes, your life was in danger and you acted in self-defense. Maybe this was imperfect self-defense. I don't know. They were trying to disarm him, but he didn't know if they got his gun, what they were going to do with his gun, or if they were going to turn it around on him or just steal it or beat him with it or what.
I don't know. I'm going to think about this one. I'm inclined to agree with Mr. Kraus. Okay.
On count 6, we are not requesting any recklessly endangering safety charges, so we can skip that argument.
Bless your soul.
Bless your heart.
Now, the defense has submitted, and I don't think you submitted anything standard, except standard on that.
Our position is they never raised the affirmative defense. So that's why we didn't do it.
At the trial.
Correct.
Let's see.
And obviously they can argue otherwise, but that's why we did not prepare one. Obviously they can argue otherwise, but that's why we did not prepare one.
I don't recall any evidence, correct me if I'm wrong, as to the third element of the second defensive matter, which you cite on the second page, on the third page. Item number 3 on the third page. I don't recall that evidence.
I would agree there was no evidence that he.
No, how can I give that instruction? Oh, because they have the burden of proof.
It's not a strict liability offense.
Yeah,
You're 17 years old.
okay. Yeah, if there's an absence in the evidence, that's kind of a problem for you, no?
What do you mean?
You would need to disprove the affirmative defense.
We don't believe it was ever raised. They never gave any evidence as to barrel lengths or that it
Oh, yes,
raised
there
the
was.
barrel length
There was definitely barrel length evidence.
on cross-examination of a state's witness.
Whenever it happened, it was there.
And
Well,
there was-
now I'm not sure. There was evidence of the length. He had the ruler out and he had measured the length of the portal.
I asked Detective Andrew.
Did you?
Yep.
Assuming that to be true, then that would, then that was less than, excuse me, it was, the barrel length was greater than 16 inches.
Sorry.
Wait a minute. Either the barrel length was less than 16th or the overall length was less than 26. That was in the evidence?
What I asked him was there any, did he believe, I want to make sure I have it right so I don't misstate it. Did he believe that the barrel length was in violation of the law?
What law? I mean, there may be, I don't know what laws there are.
The possession of a short barrel shotgun or short barrel rifle.
That's the only.
That's the law. You can't
Okay,
have a
you're
gun
talking
that's,
about, okay,
yeah.
okay.
and that's built into
Okay,
this
well,
instruction.
he certainly, come on, it's not a strange issue to this case. I mean, we've been talking about it for months.
Well, and I agree with you talking about it for months, and the defense should have measured the barrel in front of the jury and said the
You
barrel
have the
length-
burden of proof.
That they didn't. If they raise it, they never raised this issue.
Well, did he ask the detective whether it was a, what was your question as you recall it? And this is going to be dependent upon what the actual evidence was, but what do you claim it was?
When he took the gun from the Antioch Police Department, did he believe that there was a violation of the law as it related to the barrel length?
That goes to his belief in what, and they never specify which law.
They have to raise the issue.
I understand, and I don't believe that they have. And there's no testimony on the authorization, the certificate of accomplishment to obtain authorization for hunting. There's no evidence on whether or not he has a certificate of accomplishment to obtain authorization for hunting, which is the state's position all along, is that he would have to have that.
Well, they're claiming it's in the alternative.
And the state has always claimed that it is not. So we're back at, well, if the court finds they raised it, which I don't believe asking a general question on the belief of a detective, that is not evidence, the belief of someone.
Well, is it a belief or an observation?
The way Attorney Trossi just said it was belief. We'd have to get the exact question, but I don't believe.
The exact question may become important.
So I don't believe that is raising it. And the defense had every opportunity. They brought the gun over here most every day the last few days. They could go to any number of witnesses to measure it and raise this issue, and they did not.
They don't have to measure it. That's the burden of proof of it's on the state.
I understand that, but it wasn't raised. Is our
Well, if he asked the officer, and I will have to see what the transcript says, if he asked the detective whether the rifle was compliant, or what are you claiming you said?
I asked him if there was, I believe I know I asked him about it. The question I asked, I think I asked him something along the lines of, did you believe there was any violation for the barrel length of the gun?
That would put it in issue if the question is like that.
Well, also the statute reads, this section applies only to a person under 18 years of age who possesses or is armed with a rifle or a shotgun if the person is in violation of section 941.28 or is not in compliance with the two sections mentioned. So it's an or, it's not an and. We don't have to show all three. So they may have raised the issue with.
You have to show one of the three. You have to show one of the three. No. What am I saying?
No, we have to show.
You have to show any of the three which the defense has put in issue.
So
The defendant has not put in issue the certificate of accomplishment.
Correct.
The defendant has put in issue the length of the barrel.
And Judge, we can unpack this for a minute. So the exception says it's a violation of the law if you're under 18 and possess a short barrel shotgun or rifle. Okay, that's one way you can be convicted. And it says or are in violation of Wisconsin statute. I think it's 29. 29304. 29304 only applies to people 16 years of age or under.
Right.
There's been testimony that he's 17.
No.
Okay, so I've conceded because he has to be in violation of both 29304 and 29593. I concede he's in violation of 29593. However, 29304, he's 17. It doesn't apply to him. It can't apply to him because of his age. We put in his age and we put in the barrel. That covers the first exception, and then it goes to or, and it covers the second exception as well. I provided the court, and I'm not rehashing it, that you had denied the motion for reconsideration. This statute doesn't apply to 16 and 17-year-olds, period. The legislative history that I provided to the court, it says it in black and white.
Well, I ruled as I did because the motion to dismiss attacks the complaint. And the complaint was adequately pled under the law. That was not an endorsement of the state's position on the case. And to use a trite expression, the rubber hits the road here at the trial. So now you have to prove everything that the statute requires. And you dispute the fact that you need to prove that the defendant was under 18 at the time of the incident. That's not in dispute.
That he's under 18, yes.
And that the barrel length was less than that allowed by law. Or was not within the range permitted by law.
We don't have to prove that.
You don't have to prove that.
I mean, there's no real. Our argument is that they did not raise it. I don't think it's really a disputed fact, but we believe they did not properly raise this first part of the exception. The second part of the exception, they've conceded 29.5.
Go ahead. I'm sorry.
They've conceded the 29.593 portion. He did not have a hunting certificate. So then we go to 29304, and if it is allowed that simply being 17, he is in compliance with that, it swallows the whole statute, and the statute makes no sense. So if the statute
makes no sense, you're out of luck.
Well, if the statute is valid, it's clear as day that it says a person under 18
Clear
years
as
of age.
day. I would not say that about this law.
Well, I would maybe not say that about the exception, but the actual law, 2A is quite clear. Sure. Any person under 18 years of age who possesses or goes
Well,
armed
that's
with
not
a
the whole
dangerous weapon.
statute. That's not the whole statute.
Our position is that he is not in compliance with 29.304 and 29.593. And I know that this was scoffed at when I mentioned it before, but 16 and 17-year-olds can hunt alone in this state if they have the correct certificate.
Okay.
Under 16 cannot, and that is what 29.304 is addressing. The statute is addressing hunting.
No, the basic law is that the rubric is not part of the statute. The title.
The title is possession of a dangerous weapon by a person under 18.
It's not part of the statute. No, I learned it at an earlier time when we called it the rubric.
That's what the statute says, though. That's what it says in 2A. And the state's position is that he is not in compliance with those two, and that they have not raised the short barrel shotgun issue.
For what?
The short barrel shotgun issue, but they don't really have to because they can try to raise the other part, but they have not done that either.
By his age, it's raised on the second part. It's raised.
Yeah, that's true.
So that's it. And I just want to make sure I've been losing this argument. It's not, Judge, there are hunting portions of that statute, and there are just simple possession portions of that statute of 29.304. I am not focusing, and I'm asking that it doesn't apply the hunting part. If you read the Legislative Bureau, what it says is if you're 16 or 17, there is an exception for you to possess a firearm.
It does say that.
Semicolon, done. It has nothing to do with hunting. Nothing.
My inclination now, once again, I'll tell you what I'm inclined to do, is to inform the jury. Let's see.
I think this is the most interesting charging conference I've ever seen. Because they're not just talking about directions to the jury, they're actually talking about law.
Yes.
Legislative history only becomes an issue when there's ambiguity. There's no ambiguity in 2A. It is very clear that 18-year-olds are not to possess dangerous weapons. So you interpret the statute in a way that makes sense. And the way that it makes sense is that simply because he's 17 does not automatically negate 2A.
Well, I raised it earlier in the case. And it hasn't enjoyed a lot of discussion, and maybe I'm off the wall. I don't think so. The penal laws are construed strictly. Vague laws are, who is that emperor from way back in history, who posted the laws on pillars so high that the people couldn't read them? And that's been used by lawyers and judges for centuries about the requirement that people be given knowledge of what the law provides. And the basic law, and it's chipped away a lot of times with the appellate court decisions that are made on the subject of efforts to preserve the statutes, because some of them are quite messy. And that's not a criticism, that's a reality that judges have to deal with periodically. Most of the statutes are easily enough worked with. But the basic rule is that the ordinary people should be able to understand what their laws are, so they know what conduct is allowed and what isn't. And I've been wrestling with this. And now I know that there's a lot brighter judges in this world than me, but I've been wrestling with this statute for, I'd hate to count the hours that I've put into it. I'm still trying to figure out what it says, what is prohibited. Now, I have the good fortune of having some experience and a legal education. How is the ordinary citizen supposed to acquaint herself with what this law says?
Judge, there's testimony that the defendant, Mr. Black's stepfather, the defendant's mother, all knew he could not legally possess this gun. That's why he was kept up here. That's why Mr. Black bought it. This 2A is very clear.
Interpreting a penal statute?
I'm sorry?
Is that the standard by which the judges interpret a penal statute?
You just said it should be clear to normal everyday people, and it was clear to these normal everyday people. Because it's very clear that under 18 cannot possess a dangerous weapon.
They don't know the law. And he can't necessarily possess the gun in Illinois. We're talking about Wisconsin, and we're talking about the law, not what Dominic Black's father might think.
Obviously, we're responding to your.
Well, but the point is, if they put a sign out here, don't jaywalk over to the other side of the street. And that's a bad example because we know jaywalking is unlawful. Supposing they put a sign out there that said, don't don't use your cell phone while crossing the street. Now, if they adopt a law that says that, and people are, not, as I told the jury before, ignorance of the criminal law is not an excuse. So people are charged to know that, unless it's written on the top of a pillar so people can't see. People, if they're given legal notice, that's why they publish them in the newspaper. If people are given legal notice of what's unlawful, then they can conform their conduct to the requirements of the law. If they
Thank you, Nancy.
if they don't know what the law is, then they're just herded into obedience of certain standards. Now, I don't know if that's the case with Dominic Black's stepfather
Is it still
or father or whatever it was,
Yeah.
or the defendant's father or whatever.
Mayor Vince McDome.
Whether they studied the law, they were familiar with what it says, or they were just afraid to break the law because they heard somewhere along the line
What happened to the wood pile?
that it was unlawful. Well, I'm not allowed to do that. I'm not allowed to say, well, they should have guessed right. I can tell you I've put many hours into it. So have you. And how are ordinary people not supposed to know what they should be afraid might be against the law? How are ordinary people supposed to know what's against the law?
2A is very clear.
Wish it were to me. I'm going to my intention is to instruct on what he's submitted without page numbers, I might add. Looks like the third page that starts statutory definition of crime, and down to where it says or. So it'll be exception, the state must prove, etc. Then number one, the defendant was under 18. Number two, and that the dangerous weapon was either a rifle, etc. And you can search the evidence to find out if you can prove beyond a reasonable doubt that that's true, so that it can go to the jury. All right, now, is that it?
The state requested the 805, 810, and 815, as well
yes.
as 9.
Any dispute as to those?
805, no.
Okay.
810 and 815 are the retreat and provocation instructions. So yes.
Okay, go ahead.
Well, I guess I would ask this first, Judge. As it relates to 815, which is the provocation instruction, is the state saying the presence of Mr. Rittenhouse there is in and of itself provocation?
No, we are saying that in the incident of Mr. Rosenbaum, he provoked it by raising his rifle and pointing it at individuals. So that is why Mr. Rosenbaum then gave chase to him. The defendant then had a duty to retreat. He retreated. Instead of giving notice of his withdrawal from the fight, he turned and pointed his gun again at Mr. Rosenbaum, an unarmed civilian, which he admitted he knew he was unarmed, and that continued. So no, the provocation is not his mere presence. It's not his mere presence with a gun. We will argue that the video evidence, contrary to the defendant's testimony, shows that he raised his weapon at individuals, and that is what provoked the attack. By Mr. Rosenbaum.
So, Judge, yesterday, obviously you know why we were fighting about what that enlarged photo, and I don't think that's what I think that evidence is open to interpretation, certainly. I would argue to the court that while Mr. Krause can say that's what they believe it shows, I would submit to you that what the testimony is Mr. Rittenhouse is shortly before that yelling friendly, friendly, friendly. I think if you look at that picture that you saw yesterday, it's open to interpretation. We know he's wearing a strap from the harness over his shoulder. The other thing that if you look at the picture closely, he's standing like he would be firing or pointing that gun like he's left-handed. So if you look at the picture, his left foot is back, his right foot is forward, and he's open like you're looking at me now. So in every other instance where you observed a gun being fired, he's firing it from the right side with his strap as his gun hangs this way. Now they're saying that photo shows that he was standing and picking the gun up and doing it left-handed. I think that photo is open to interpretation as to what it is. We believe that it shows a side mirror of the Duramax and part of his strap from his firearm or from his sling. That's open to interpretation. I completely understand that. However, you also heard testimony that from this person from the state crime lab, who said he couldn't really answer, and I don't know what you thought of his testimony yesterday, but he really couldn't answer a lot of questions on, and that's why color was so important yesterday, on how the pixels work, and he couldn't say what color those pixels add, and I think that's relevant. Now, it is our position, and I think the testimony supports the idea that Mr. Rosenbaum provoked the attack.
That Mr.
Rosenbaum provoked the attack. Mr. Rosenbaum, there's testimony from two people that Mr. Rosenbaum threatened to kill Mr. Rittenhouse if he caught him alone. You heard the testimony that Mr. Rosenbaum yelled, gun, gun, gun. And then you know what was said after that. He's chasing him down. He yells, there's been testimony that Mr. Rosenbaum yells, F you, before this happens. Mr. Rosenbaum has a gun pointed at him in the parking lot and doesn't stop running toward Mr. Rittenhouse. And if you give 815, which is the provocation instruction, I would submit to you the only way that Mr. Rittenhouse then can be acquitted or found not guilty of the charge is, one, he exhausts every other reasonable means of escape. Two, he withdraws from the fight, and fight is the language in the instruction. And three, he provides. Sorry.
Well, go ahead, finish, and then I'm going to tell you why I don't agree with what you're saying.
Okay. Well, I'm looking at 815, but
I'll interrupt you now and tell you.
Okay.
You said if I give that instruction,
Yeah.
then the only way. No, the jury may not believe the predicate facts upon which the instruction is based. So he could be acquitted as long as the jury does not believe that the defendant's behavior was provocative.
That's the first line of the instruction.
But say that again.
That's the first line of the instruction. You should also consider whether the defendant provoked the attack. The defense is still able to give forward their version of events. We have multiple videos in addition to this photograph In addition, and also a defense exhibit number 41, which has its circle on there where the defendant is raising the gun at someone in front of that Duramax. That's an exhibit they have gotten into evidence. So there really wasn't much dispute of this until a few days ago, and that's fine. They can dispute this fact. We believe it's very clear on video that the picture itself is just one little portion, but on that drone video, both the full version and the somewhat zoomed in version that has been provided, it's very clear. I saw it on my television at home immediately upon watching it. So that's our argument, is that he provoked it by doing that. Now, as the court has pointed out, this is not forcing the jury that there's it's not forcing their hand. They don't have to find provocation. You should also consider whether the defendant provoked the attack. And that is a consideration, and that is a point of contention in this case. And I believe it's an appropriate instruction for both incidents.
Judge, the last
I
thing-
interrupted you.
No, that's okay. The last thing that I was going to say is it would also require that he give Mr. Rosenbaum adequate notice that he is withdrawing from the fight or the attack. I think under those circumstances, that's impossible to do. But more importantly, I have found a case, it's from Kenosha, on provocation and what that means in terms of a self-defense. That is state versus, and I'll just spell it, it's Boughnet.
Spell one more time.
Boughnet. It's at 97 West 2nd, 687. And in that case, there was a gentleman in a diner, and people walked into the diner and he started to harass them. He tried to grab the women, harassing the women, verbally accosting people. And one of the men that the women were with came over and said, "You need to apologize." The defendant said, "Let's go outside." So they go outside. The defendant ends up going to his car, picking up a shotgun and shooting the man in the face. And the argument was, did he provoke this? Now, there was testimony to everything that I just told you. Did he provoke that by starting the fight, sexually harassing the women, using the language he used, and then asked the guy to come outside? And the court said he did. So the provocation instruction is clearly appropriate. I don't believe there's sufficient evidence in this
So
record
That's
to
legal?
support the idea that Mr. Rittenhouse provoked this attack. I don't think that that's there. So I understand that it doesn't require that they follow that and say, well, he did provoke it, but I think there has to be evidence to support that. And I don't think that photograph in and of itself, which is obviously open to interpretation, supports the idea that they have to or should consider whether or not that was provocation at that point.
May I respond? I agree that photograph alone would not give the basis for provocation. The photograph is the last piece of evidence that was submitted on this. Detective Antorini testified to it. We have pointed it out on videos. We pointed it out to the
Barely
defendant on
make
the
out
video,
what it is.
and he gave what I believe to be a lame explanation for it. So, and again, the defense's own exhibit has it circled on there as it happening. So I believe there's plenty of evidence that Mr. Rittenhouse did raise this rifle and pointed at someone off in the distance, actually Mr. Zeminski. And let's not forget also, I'm not giving my full argument on provocation yet. The FBI video, well, let me go back. The Corey Elijah and the Drew Hernandez, actually Frank Hernandez videos, shows the defendant walking behind Rosenbaum, Mr. Rosenbaum, on the way to this car source area. At some point, Mr. Rosenbaum begins running. We see that on the FBI plane footage. Our argument is that Mr. Rittenhouse then begins running and following Mr. Rosenbaum. That he follows, if not the whole way from the Ultimate gas station, then Mr. Rosenbaum starts running, that provokes the defendant, who is actually very slowly and casually walking for quite some time, seemingly, to then go and follow Mr. Rosenbaum there. He then and the defense's argument is that this is some sort of ambush. And I don't know how you ambush someone that you don't know they're there, but we'll put that aside.
What?
I don't know how you ambush someone you don't know is coming, but we're going to put that aside. So
Yeah.
the defendant runs onto the scene and then is seen by testimony and video evidence gently putting the fire extinguisher down. He says he dropped it, but he places it on the ground and he raises the gun. And I disagree about the left-handed thing that Attorney Trofsky just said, and raises it at Mr. Zeminski. That is all in evidence. It's in a defense exhibit.
Can I see that? Is that readily available? Bear with me 1 second.
The state's position is that the running after Mr. Rosenbaum probably in itself was enough to provoke the attack, but putting that aside, certainly raising a gun and with no basis for any kind of self-defense. There's no one around him at the time except an individual in a wheelchair who's behind him. He raises his gun, I would guess, because he thinks there's vandalism going on, but we don't know that because the defendant denied that he did it. And then Mr. Rosenbaum approaches, he somewhat drops the weapon, he keeps two hands on it, and then he has a duty to retreat at that point under provocation, and then he runs. I understand why this instruction is problematic for the defense and for their version of events, but that does not change the fact that pointing a gun, which is in the evidence, is provocation. The defense is
Well, wait a minute, no. Oh, you will see if you can find it. Which exhibit are you talking about?
Talking about the compilation video that the defense put into evidence, I believe it's 41.
I have it on my screen right now on my computer, Your Honor.
Then you said, we'll see if you can match it up with what she's looking at. Then you said that something about the one person running after another was provocation. Well, how is that provocation? We're talking now about you're alleging that the defendant was running behind Mr. Rosenbaum, and that was provocative?
That he chased him there.
Your Honor, you can talk all about the evidence. He's walking, especially in the video that was put in yesterday through Mr. Hernandez.
Yeah.
He's walking within steps. Rosenbaum and Zeminski are lighting the garbage can on fire. He sees my client walking down the street with a fire extinguisher, and there's fires down at Car Source. Mr. Rosenbaum knows where he's going. He's already threatened to kill him. He sees him coming. He's got very distinct purple gloves. He goes down and he lies in wait. There's no chasing going on whatsoever.
Where's the chasing? And where is the chasing? And how is that provocation?
The provocation is the raising of the gun.
Oh, so because a moment ago you said that the chasing was provocation,
I believe it
which
adds,
of course it could be
I believe it adds
if it's
to
in the
I'm
evidence.
sorry.
You just
I believe it adds to the
What?
provocation that he chased him there and then immediately raised the gun.
He wants the instruction, and then he's going to argue what he just said 5 minutes ago.
Well, and we're free to argue that.
Just like we're free not to stipulate to the third element.
What am I looking at? There's a circle.
I don't believe it's playing yet.
Show me with the pointer what you're talking about.
I'm just pointing out that it indicates he's pointing a weapon.
Huh?
My only I'm just pointing out that this defense exhibit indicates he's pointing a weapon. We have much clearer video showing this.
And it still has Rosenbaum behind Rittenhouse, if that's Rittenhouse. I'm gonna just step out for 1 second. I'll be right back.
We'll take a minute.
Okay. So, this is a very, very long charging conference. But like I said, it's pretty interesting because they're actually discussing the charges. And most charging conferences, they just stipulate to the charges and they go right to jury instructions. So, this has been really interesting. I've enjoyed it. We're not done yet, though. We'll do more tomorrow. But now we're going to go over to Banfield. If you know the verdict, I let it out of the bag this morning, but hopefully nobody caught it. It was an accident. If you know the verdict, please, no spoilers. So we're going to head over there. It should redirect you. So we'll see you over there in a minute.